Whatever may be the law of custody, paramount
interest of the child. Lordship,
and 14-year-old child has intelligent preference, Mr. Chatterjee.
in life, would you go to your father's house? Answer, I do not want to go to my father because he never came to see me and my mother, and I had not seen his face since my birth.
You are the mother or the father?
I'm for the father. I was the
Age of the child, Mr. Chatterjee?
my lord. The child's age is presently.
Yes.
So it should be
Male or female?
14 years, male child.
14 years?
14
Boy,
years, I
yes.
should- 14 years, my lord. I will subject to it.
So you filed an application for guardianship and custody.
And finally, it has been decided, my lord. Finally,
No-
it has
no
been
visitation
decided in
rights
favor
given?
of the mother. 13 years old, my lord. I stand corrected.
No visitation right given to you?
Nothing. Lordship, kindly come to this. It's kindly come to paragraph number 22 onwards of my. This is the judgment. Internal page 7.
Yes.
Of the judgment, paragraph 22. Admittedly, the petitioner has got second marriage, and out of the said second marriage, he has 3 children who are all female babies. And as his second wife could not give birth to male baby, he might have taken the calculated attempt to take the said child back to his house. In this perspective, the child witness is telling the truth that he never spent a single day with his father since his birth. And said child witness also found firm when the court put the following questions: your father is a rich man and he can provide you better amenities in life. Would you go to your father's house? Answer, I do not want to go to my father because he never came to see me and my mother, and I had not seen his face since my birth. My lord, kindly come to paragraph, because the entire the judgment has been passed upon the sole consideration that it is passed in for the sake of the welfare, paramount welfare of the child. My lord, the 24 records, with regard to the amount of income or source of income of the OP, it is pertinent to mention that she works as maid, whereas the petitioner has stated before the court that he is a day laborer. Therefore, none of the parties has definite fixed income. For both of them are more or less on same footing, and so argument of the petitioner that he has sufficient means of income that OP is not convincing. My lord, there is no definite finding on the how the welfare would be taken care of. My lord, I am a daily laborer, admittedly, and even the court did not arrive to the finding that my wife, uh, who is presently been granted with the custody, whether she has that amenities. There is no definite finding on this. Para 27, my lord, this is another part where I found there is an error with regard to this issue. The pertinent to mention that under the Guardians and Wards Act, this court has no authority to appoint a guardian of the minor whose father is alive. It is also fact that under Mohammedan law, a father is entitled to get the custody of the child if the child has completed.
Both of you belong to the Muslim community?
Yes, my lord. That is the another point on the basis of which this was moved, that after 7 years that I becomes the. Now this issue has been subject to correction, my lord. It has been dealt in a different manner. It is also fact that the under Mohammedan law, a father is entitled to get the custody of his child if the child has completed the age of 7 years and the father is found fit person to receive the custody of the child. Here in this case, admittedly the petitioner has married second time, and out of the second marriage, 3 children are born. On the other hand, the OP has not remarried, and therefore she is in a better position than the petitioner, and mother could provide better care, protection, and said child. Right. So this finding also has been arrived on the basis of very feeble logic, lordship. What I found.
We
And-
find it a strong logic, Mr. Chatterjee.
My lord,
Your second marriage, you have no objection with your second marriage. You have 3 children out of that marriage.
yes, my lord.
You are a day labor. Now you have to take care of, if this child goes to you, you will have 4 children for whom you have to take care. It will be difficult not only financially, whatever may be your income as a day labor, the maximum that you can earn, it will be a burden on you also and the family also.
But
And compared to that, if a comparison is made, she also works as a domestic help in houses. But she has only this child. She has not remarried. So the child is in better hands.
lordship,
You don't find any difficulty.
so
with
there
this?
is no
And Mohammedan marriage, this Hindu marriage, Mohammedan marriage, the Hindu law, Mohammedan law, Whatever may be the law of custody, paramount
paramount
consideration
interest
you
of
know.
the child. Lordship,
And 14-year-old child has intelligent preference, Mr. Chatterjee. His preference was taken. What is the difficulty?
even no
We can at
visitation
best look
rights has been
into
given.
visitation right scenario, and we'll admit the ground only on that limited point.
Kindly,
Only on visitation will make it clear in our order.
at the same time, Lordship, that though it has to be established after that from the depositions, Lordship. Uh, so far, my statement regarding the day laborer is concerned, Lordship, I can show my earnings also. Lordship, kindly consider that aspect also, and kindly grant me in an opportunity to perform my duties towards the child. My lord, kindly ensure that.
No,
If your lordship
we'll
is
direct you to
inclined
serve
to
copy
admit
of.
it, yes.
We'll admit the appeal. We'll admit the appeal. We'll say that on the limited ground of visitation rights, you're entitled.
Well, kindly.
We'll make it clear in our admission order, and Mr. Chatterjee will direct you to serve copies of the memo and the application on the respondent.
My lord.
We'll not pass any visitation order right now without hearing the other side. We can give a short date. We can keep it on 1 week after the reopening.
My lord, kindly.